built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
Good morning, everybody. Thanks for joining us on this call today. I am Marcy Koski, and I am a partner in our Madison office and the co-chair of our firm's Consumer Financial Services team. HB has 19 offices across the country, including here in Wisconsin. Our other states include Illinois, Texas, Missouri, Tennessee, Colorado, and Arizona. We are a full-service law firm with a very deep expertise in the consumer financial services industry. We pride ourselves on knowing not only the law, but also the business of consumer financial services. A little quick bit about me. I have practiced in this space my entire legal career. I regularly advise non-bank finance companies, credit unions, and banks on compliance obligations under applicable state law, including, as relevant here, the Wisconsin Consumer Act, the Wisconsin's Licensed Lending Statutes, and the Wisconsin Marital Property Act, as well as obligations under the various federal alphabet soup regulations like ACOA, FCRA, and the GLBA. I also represent clients in litigation at every stage on these various laws. Before I introduce the rest of the panel, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, please know that we will call or email you to discuss your question. A PDF of the presentation is available in the resources folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Finally, toward the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. All right, that's all for the housekeeping items. Let's get started with the program. We have a great lineup of presenters and topics for you today. Joining us will be Lauren Cappatini. Lauren counsels financial institutions and lenders of all sizes, along with document providers and loan origination systems on the alphabet soup of the federal consumer finance regulations, along with the intricacies of complying with the Wisconsin consumer requirements. This translates into, among other things, drafting contracts and disclosures and policies and procedures, advising on matters with federal and state regulators, and as of late, Lauren has been helping lenders navigate the complexities of servicing hemp and marijuana-related businesses. While Lauren has a deep understanding of the law, she understands how lenders operate and is able to bring a pragmatic approach to compliance. Lisa Lawless is a highly experienced litigator with over 25 years in practice, the last 15 of which have been focused on representing companies operating in the consumer financial services space. She is a seasoned appellate attorney handling a significant number of Wisconsin Consumer Act and other consumer appeals in both state and federal appellate courts. She has argued in front of the Wisconsin Supreme Court 5 times in the last 10 years, including the Kirsch case last year, which we'll remind you about during this webinar. I, of course, want to mention our colleague Natalia Cruz, who, although not in today's lineup, was integral to our preparation today. Natalia is a promising and fast-rising consumer financial services litigation star, and we are so excited to have her on our team. Finally, we are very pleased to be joined today by Matt Lynch, the Wisconsin Department of Financial Institutions Chief Legal Counsel. Matt has been with the Wisconsin DFI since early 2019, when he was appointed to serve as the agency's Chief Legal Counsel. Before that, he spent almost a dozen years in private practice with Foley and Larner, where he assisted clients with business litigation and dispute resolution, and served as a director and past president of the Wisconsin Equal Justice Fund. We are very pleased to have him today, and we are looking forward to the insights that he will share with us. Okay, moving into the program. To set the stage, I'd like to just briefly discuss the Wisconsin Consumer Act. So the WCA enacted a number of the model UCCC provisions, so it is loosely a UCCC state, but it also enacted a number of provisions contained in a model law that had been proposed at that time by the National Consumer Law Center. When it was first passed, Ed Heiser, my mentor, friend, and former colleague, now retired, wrote that the passage of the act ushered in what is probably the most sweeping consumer credit legislation yet enacted in any state. Unfortunately, that is now an oft-cited quote by many plaintiffs' counsel and in 1 or 2 court decisions, much to the chagrin of Ed. Let me hit some highlights of the WCA. The WCA contains a unique definition of default. It is not merely when a customer misses a payment. It requires a notice of right to cure and a 15-day cure period before acceleration, filing a lawsuit or attempting repossession. If a lender wants to undertake self-help repossession of motor vehicle collateral, it also is required to give a notice regarding repossession and a 15-day right to object to self-help repossession, which runs concurrently with the 15-day cure period. It also prohibits a fee-shifting provision in a consumer credit contract, shifting fees to a consumer if a lender prevails. On the other hand, it includes a fee-shifting statute if the consumer prevails, which often results in a lot of litigation here in Wisconsin. We will touch on all of these provisions throughout our webinar as we discuss recent litigation. And I just also want to point out another statute in the Wisconsin Consumer Act, Wisconsin Consumer Act debt collection statute. This too has created a lot of litigation. It prohibits egregious debt collection behavior, and we will also touch on this statute during the remainder of the presentation. With that, I will turn it over to Lisa Lawless.
Thank you, Marcy. The first case we're going to talk about today is Security Finance versus Kirsch. It is a Wisconsin Supreme Court decision issued in 2019. The Supreme Court doesn't decide that many WCA cases, and this is the first one in 20 years. The issue in Kirsch was, is a lender's filing a lawsuit for collection on a debt a violation of that debt collection statute that Marcy just referred to, 427.104. It is filing suit without sending a proper notice of cure first, a violation of that statute. The court held that no, it's not a violation of the debt collection statute. failing to send a notice of cure before filing suit is just a violation or a non-compliance with a procedural requirement of the WCA. Sending a notice of cure is something that's supposed to be done before a lawsuit is filed. If that doesn't occur and it's raised by the debtor, then that is a basis to dismiss the action without prejudice, meaning the lender can just start over again, send a proper notice, and file a new lawsuit. The Wisconsin Supreme Court held that it doesn't violate the debt collection statute of the WCA to file suit without sending a notice of cure. The Kirsch, the consumer in that case, said that filing suit without sending a notice of cure is one harassing or threatening conduct under 1H of the debt collection statute, and the Supreme Court promptly rejected that argument, holding that the debt collection statute's prohibition on threatening and harassing conduct is really supposed to be for egregious conduct, not for merely not checking a box under the WCA before filing suit. The other claim of the consumer for debt collection violation was that security finance was enforcing a quote unquote right that it didn't have by filing suit without providing a notice of cure first. The Supreme Court again rejected that argument, holding that the lender security had the right to enforce the debt under its loan contract with Kirsch. It had the right to sue because Kirsch was admittedly in default under the loan. The filing suit without a proper notice of cure wasn't enforcing a right that didn't exist. I personally argued the Kirsch case in the Wisconsin Supreme Court, and the decision is just a fabulous one for lenders in our view, and a correct application of the WCA in our view as well. I'm going to turn it over to Marcy to discuss application of Kirsch in the bankruptcy setting.
Thanks, Lisa. Okay, so since Kirsch was decided, at least one bankruptcy court has applied Kirsch in the context of an adversarial complaint. In the Bratz adversarial complaint, the debtor alleged that Check and Cash, the lender, violated the automatic stay in the Wisconsin Consumer Act debt collection statute when it garnished her paycheck after she filed for bankruptcy. So the background to this, the lender obtained a judgment in February 2019. Then it obtained a lawful state order to garnish the debtor's wages. And 1 month later, the debtor filed for bankruptcy. 2 weeks after the debtor filed for bankruptcy, her paycheck was garnished in the amount of $266 by the creditor. Bratz filed an adversarial complaint alleging violation of the automatic stay in the WCA debt collection statute. Notably, 2 weeks after the adversarial complaint was filed, the creditor returned those funds to the debtor, but nevertheless, this proceeded in bankruptcy court. The lender did not make any appearance and defaulted on the complaint. The judge, based on the default, determined that the lender willfully violated the injunction and awarded damages to the debtor on that basis. It then turned to whether there was a violation of the Wisconsin Consumer Act debt collection statute. In reviewing whether there was indeed a violation of the debt collection statute, the court looked to Kirsch. And in looking, let me back up, the claims under the debt collection statute were the exact claims made by Kirsch in the Kirsch case. So the debtor alleged that the lender violated the debt collection statute's provision prohibiting a debt collector from engaging in threatening or harassing conduct to the customer, and violated the provision that prohibits a debt collector from enforcing a quote unquote right that does not exist. The court outright rejected the claim that the garnishment was threatening or harassing behavior. Simply receiving garnished wages from a paycheck under a lawful court order can hardly be considered harassing or threatening, according to the court. It also concluded that it was not claiming or enforcing a non-existing right by garnishing wages. So in that instance, the court applied Kirsch, and it determined that, like the state law notice of right to cure requirement, the bankruptcy injunction did not eliminate the creditor's right to collect from frauds. Instead, that injunction merely stays the creditor's ability to exercise that right, other than through the claims allowance process in the bankruptcy court. As noted on the slide, this is on appeal to the district court. And unfortunately, in that case, or on that appeal, again, the creditor does not appear. However, we note that the case is in front of Judge William Griesbach, who is arguably the best judge to be in front of on a creditor issue in the state. We're optimistic that he will take heed of Kirsch and undertake an independent analysis of the issues. We feel the bankruptcy court made the right decision, and it is a position that we've been taking in a number of cases on behalf of our clients, where the debt collection statute is alleged to have been violated. For example, in our cases, if a plaintiff alleges that a lender picked up a car without sending a proper notice of right to cure and notice regarding repossession, and therefore, in plaintiff's view, violated the self-help repossession statute and also violated the debt collection statute because the lender was trying to enforce a right it did not have by failing to send the proper notices. We argue that that's simply not true. The lender did have the contractual right to pick up the vehicle with or without sending the notice of right to cure and notice regarding repossession under Kirsch. And therefore, under Kirsch, it is not a violation. If the decision here is affirmed, it will be persuasive precedent to support that argument. However, in Russell v. Santander, which just came out earlier this summer, and which Lisa will talk about momentarily, the court, and that was a federal court, did not apply Kirsch in finding that there was a violation of the debt collection statute for a violation of the self-help repossession statute on the basis of a breach of the peace, not a failure to send a proper notice of right to cure or notice regarding repossession. So now I'm passing it back to Lisa to discuss another right to cure case. Lisa? Okay.
Oh, it would help if I unmute myself. Thank you. I'll have to make up more time. It was really brilliant what I said, but anyway, unless you can read lips, then you know otherwise. The next case is Brumfield versus Westlake. That's a case that Husch Blackwell also handled in the Court of Appeals of Wisconsin and the trial court. And that was a repossession case. And the question in that case was a notice of cure, notice of repossession document was sent to the customer before the repossession. But the issue raised by Brumfield challenging the propriety of the repossession was, did the notice of cure have the right information in it that was sent to him? Under the statutes that Marcy mentioned before and that are listed on the slide, there are specific pieces of information that need to be in a notice of cure in order for it to be effective under the WCA. Also, a required notice is the repossession statute for self-help meaning non-judicial repossession, requires certain information to be included in the notice as well. And we have seen over the years claims by consumers raising a wrongful repossession because the notice of repossession / notice of cure didn't have all the information required by the statute. If the notice doesn't comply with the WCA and the court finds the repossession was therefore improper, this leads to significant damages under the WCA 425.206. The debt is voided in that case. The customer gets all the payments made back, and the customer gets to keep the collateral, or if it's already been sold, gets the value of the collateral. And on top of that, of course, as Marcy mentioned before, the WCA entitles the customer to attorney's fees, which are often the most significant amount of damages and exposure for lenders that we see. In Brumfield, the customer was undisputably in default under his loan. The lender, Westlake, sent a notice of cure / notice of repossession. The customer is entitled under the WCA to cure a non-payment default by paying all payments due at the time of the notice of cure. In this case, the customer had missed the March payment and didn't make it in full. And at the time of the notice, which was in May, he had missed his April payment too. So the notice of cure listed both the missed March payment and the missed April payment for the total amount due. Brumfield argued that the notice was ineffective and violated the statute because that was not the proper amount due under the WCA. The trial court rejected his argument and granted summary judgment, dismissing the action to Westlake. Then the consumer appealed, and he made the same arguments, nothing new. And the Court of Appeals also agreed that the notice of cure was proper and that the court properly dismissed the action.
Lisa.
Yes?
Oh, I'm sorry. Go ahead. I have a question when you're done.
Go ahead. Oh,
Can you tell us a little bit about your win on attorney fees with this case?
Sure, Marcy. The one thing about Brumfield is that the borrower's attorney just sort of filed a rudimentary appeal brief and didn't make any new arguments. His arguments in the trial court were simply wrong under the statute. So in Wisconsin, you can move for attorney's fees arguing that the appeal is frivolous. And so we filed a motion for attorney's fees for our fees on appeal, that the appeal was frivolous, and we were thrilled to see that the Court of Appeals agreed. We won our attorney's fees on appeal, which can be substantial, and Brumfield's lawyer had to pay our client its attorney's fees. The other thing about this case is that it was a per curiam decision. That means that it can't be cited in any other court proceeding as authority or even persuasive authority. However, this case is out there and can be easily found on the court's website or on Westlaw. We will often cite this to consumers who threaten our clients with suit or who file frivolous actions to show that courts will award attorney's fees if the case is unfounded under the WCA. Now I will turn it over to Lauren, who has another case relating to a claim of wrongful repossession under the WCA.
Thanks so much, Lisa, and that's such great information. Good morning, everyone. I'm gonna walk you through a recent decision that came out in July of this year, Duncan versus Asset Recovery Specialists, yet another WCA case. And so this case is really just a classic case of a loan gone bad and attempted repossession. So the facts of the case are really as follows. Ms. Duncan defaults on a vehicle loan with Wells Fargo. Vehicle is collateral for the loan, and the bank proceeds via repossession company, Asset Recovery Specialists, with non-judicial self-help repossession under the Wisconsin Consumer Act. Now, it's undisputed that the bank met all requirements under the statute to proceed with the repossession. And so that's what they did. Now, a little bit of background on the law itself. As you've heard earlier from both Lisa and Marcy, the Wisconsin Consumer Act permits non-judicial or self-help repossession. As you've also heard, and as you all on this call well know, advance notice is required and 15 days must lapse before you're able to actually repossess in this case. Additionally, the Wisconsin Consumer Act prescribes things that you cannot do when you repossess. Namely, you cannot breach the peace. And we know that that means really no oral, unequivocal protesting by the consumer when you come to repossess the vehicle, for example. And then second, in repossessing, you cannot enter a dwelling used by the consumer as a residence. Okay, so bearing that in mind, we don't want to violate these provisions, folks. We don't want to violate them because it comes with steep penalties, namely the Jackpot Remedy. And the Jackpot Remedy entails the following. Debt is voided. Any payments made by the customer must be returned to them, and the customer gets to keep the value, the collateral, or the value of the collateral. So again, really important to adhere to these requirements under the Consumer Act. Getting back to the facts of the case. So here's what happened. So the bank hires asset recovery specialists to go get the vehicle. Asset recovery specialist goes to the residence of Miss Duncan. Miss Duncan lives in a multi-story, multi-unit apartment complex. The garage where her vehicle is located is an underground parking garage with many vehicles to support the tenants of the building. So think, your classic downtown apartment complex. So when ARS arrives, the garage door or the gate is actually left open. So they simply enter and Miss Duncan's vehicle is inside and they repossess the vehicle. So the question for the court here, there's clearly no breach of the peace. Nobody ran out and protested the repossession. The question was whether when ARS entered the garage, did it enter a dwelling used by the customer as a residence? Okay, so what did the court say? The court said, yes. The garage that they entered is considered to be a dwelling used by the customer as a residence. Now, folks, this is an interesting one, and we do not think that the court got it right here. And it has some implications for lenders on this call. But before we get to the import of this decision, I'd love to bring in my colleagues to give a little flavor to the discussion of why we think the court got it wrong. So Lisa, would you like to chime in and talk a little bit about where we think the court went wrong here?
Thanks. Sure. Thanks, Lauren. In this case, the Supreme Court didn't, in applying the statute, just simply look at the plain language of the statute. Entering a dwelling that the customer uses as a residence is very common sense. It can be determined by looking at the dictionary, and the court didn't just simply take that language, apply it to the facts, and determine whether the lender entered a dwelling the customer used as a residence. Instead, the court went beyond the words of the statute of that particular section, looked at other sections of the WCA and even regulations, and thought about the overall broad policy of the WCA and even issues of breach of the peace, which isn't even at issue in this case because the repossession occurred when no one was around, so there was no breach of the peace. The court considered a lot of things that are totally irrelevant to determine that the WCA was violated. Marcy, what do you think the practical implication of the Duncan decision is, assuming until it's reversed, if it is?
Thanks, Lisa. That's a great question. So it's so interesting to me because the court, as a policy reason, really looked to why we have 425-206, which is our self-help repossession statute, and why breaches of the peace are prohibited or illegal, and it's to avoid inciting violence. So the practical effect of this, many courts and other commentators, and in fact, experts we've seen in court opine on this, that repossessions should really be taking place when a debtor is not around, and therefore the best time to repossess a vehicle is usually in the evenings. Well, this decision coming out will really prohibit or reduce the opportunity for a repossession company to take possession of a vehicle that might be in an open multi-unit space, and therefore could have the exact opposite effect, which could lead to more breaches of the peace, because our repossession companies will have to look for and try to secure the vehicles more often during the day. So very interesting position to be in.
Thanks, you guys. And so the way it stands right now, this is not a great decision for lenders or repossession companies. We think it certainly expands the universe of repossessions that are going to run afoul to the Wisconsin Consumer Act, and certainly could incite more litigation, bringing, both lenders, even if not liable, as well as repossession companies into some claims. Now, it is on review, or there has been a review submitted to the Wisconsin Supreme Court. It's been requested. We'll see where that goes. So with that, I am going to turn it back over to Lisa to talk about another wrongful repossession case. Lisa?
Thank you, Lauren. The other repossession case that we wanted to bring to your attention is Russell v. Santander. It's a case out of the Eastern District of Wisconsin Federal Court. It was issued on July 30th of this year, and it was briefed over 2020. It's a case that involves the issue of breach of the peace of a repossession, as well as whether there was a violation of the debt collection statute that we've talked a lot about today. In Santander, the repossessor, proper notice of cure and notice of repossession was sent first. That's not an issue. Then the repossessor came to the customer's residence, began to take action to repossess his vehicle. The customer presumably looked out the window, saw what was happening, grabbed his gun, went outside and told the repossessor to get off his property, told him he had a gun, or pulled it on him, depending upon who you believe. So the customer objected. And if you proceeded to repossess when the customer says, no, I'm not going to allow you to repossess, then that would by law be a breach of the peace, which makes sense. The repossessor rightfully, correctly left, didn't repossess the vehicle at that moment. He called the police, presumably because he was upset and shaken by having a gun pulled on him. The police arrived in either 5 minutes to 20 minutes, depending upon who you believe. The customer was taken and put in the police car, handcuffed. And then the repossessor, I think he was just down the street, came back and then repossessed the car. There wasn't anyone around to object to it at that moment. The issue in the Russell case was that a breach of the peace? Did the customer's original objection to the repossession effectively still apply? The judge found that given that it wasn't that much time that elapsed between the original objection and the repossessor coming back to take the car, that was a breach of the peace because it was a repossession over the objection of the customer. Also in that case, the customer argued that it was also a debt collection violation because repossessing in that situation was harassing and threatening, also under 1H. And also the consumer argued that it violated 1J, which is enforcing a right that the lender doesn't have. And the consumer argued that calling in the police was enforcing a right that the lender didn't have. We see in these kinds of cases that lenders' lawyers often argue that there's a breach of the peace or a violation of the debt collection statute if you call the police to assist with repossession or even to keep the peace, which is totally counterintuitive and doesn't necessarily make sense. The district court held that the debt collection statute was violated, that the repossession in this instance, a repossession while breaching the peace, harassed and threatened the customer and was something that the lender didn't have a right to do. The court also held that the Santander was liable for the agent's violation, even though Santander wasn't present to conduct the repossession.
Gosh, Lisa, it sure seems like the court concluded that 427-104, the debt collection statute, is sort of a catch-all for any violation of the Wisconsin Consumer Act. Was that really intended to be a catch-all? Can you comment on that at all?
Of course. It is 427-104, the debt collection statute we've mentioned many times today, is not a catch-all. It has a list of specific conduct that's prohibited, and it's very clear. And in fact, in the Kirsch case, the consumer's lawyer argued that any violation of the WCA, any of the various sections, is also a violation of the debt collection statute. In Kirsch, the Supreme Court rejected that argument and applied the prohibition list as written. Unfortunately, in the Russell case, none of the defendant's lawyers were aware of Kirsch. It had been issued the year before. They didn't cite it. If they had raised Kirsch to the district court judge, she's a very good judge, I think the decision on the debt collection statute may very well have been different. Applying Kirsch, the lender should not have been liable under the debt collection statute, in my view, and only for the breach of the peace under the repossession statute. Now, I'm going to turn it over to Lauren. We're going to switch to DFI guidance that's been issued of late.
Thanks, Lisa. Yeah, so DFI has been pretty active in issuing guidance lately, much of which has been in the wake of the COVID-19 pandemic, and which we're glad to have Matt talk about later as well. But this first one actually does not have to do with the pandemic. The first guidance that we're going to talk about is guidance on attorney fee provisions in lender contracts. So on July 7th of this year, DFI issued guidance on this topic. Now, specifically, an attorney had requested that DFI invalidate certain provisions of lender contracts with borrowers that he felt were inconsistent with the Wisconsin Consumer Act. And the Wisconsin Consumer Act provision that's at issue here is up on your screen. It's Wisconsin 422.411, which basically says that you cannot have a term of a writing that provides for the payment by the consumer of attorney's fees. The intent of this provision was really to prohibit fee shifting to consumers, such that if they brought an action under the Consumer Act and were not successful, that they would shift their attorney's fees, or the lender could shift their attorney's fees to the consumer. That was what was intended to be prohibited here. Now, there were 3 provisions that were submitted to DFI in hopes to have them invalidated. I'm not going to go through them in detail, but the first 2 provisions here are simply a restatement that in contract that a lender may be awarded statutory attorney's fees, which would be allowed by law. And the third, it doesn't really provide for any sort of fee shifting. That's certainly not the intent of those provisions. The third provision here says that the seller or the lender would be able to recover attorney's fees to the extent not prohibited by law, which is really a savings clause. And typically you're going to see that third provision in contracts where the contract is intended to cover Wisconsin Consumer Act loans as well as non-Wisconsin Consumer Act loans. And to provide that in non-Wisconsin Consumer Act loans, perhaps attorney's fees can be recovered. So those were the provisions at issue. And what DFI said is the contractual provisions do not violate the Wisconsin Consumer Act. All three of those do not violate the Wisconsin Consumer Act. That really the WCA bans that fee shifting that we discussed, and none of those contract provisions attempt to fee shift. So the import of this is good news for lenders. We know that many of you on this call, lenders throughout the state are operating in this state, have these provisions. Many have these provisions in their contracts, and so we're certainly pleased with the outcome. But it's always a good reminder just to check your contracts, make sure that you don't have any language contained therein that might run afoul to the Wisconsin Consumer Act. And so with that, I'm going to turn it back over to Lisa to talk about some guidance that was issued in the wake of the COVID-19 pandemic.
Thanks, Lauren. On April 13th, DFI issued emergency guidance on prohibited debt collection practices. This is guidance that arises in the wake of the global COVID-19 pandemic. And that guidance, we have it quoted on the slide, it deals with the debt collection violation statute that we've talked about before, and specifically 1H, which prohibits lenders from engaging in other conduct reasonably expected to threaten or harass the customer. The guidance of DFI says that harass is not defined by the statute and notes that in the global pandemic context have a different meaning. I think in these difficult times for people who are losing their jobs, getting furloughed, having less money, having more health expenses potentially, they are more likely to be harassed by collection calls. So the DFI's guidance is advising lenders to be mindful of these new economic conditions, that the context has shifted dramatically. DFI suggested that lenders maybe shouldn't be wasting time doing business as usual, making collection calls to customers who haven't paid, leaving the phone for other calls the customer may be expecting that are, in DFI's view, more important. And also DFI notes that if there's a harassment claim under the debt collection statute, a jury may not look too kindly on a lender who's making a lot of phone calls to a customer to collect a debt during this difficult time period. The attached to this guidance is and referenced in it is an interpretive letter that DFI sent to a lender regarding the lender's contacting of its customers, friends, and family to locate the customer when the customer missed a few payments. That letter, that set of events occurred not in the pandemic, prior to the pandemic, but in that case, an auto loan servicer made 23 calls to friends and family of the borrower as a result of 2 late payments by the customer. The DFI asserted that that's a violation of the debt collection statute. And the servicer, on the other hand, argued that calls to references are customary in the industry. The DFI's interpretive letter finds that the debt collection statute 1A many times to fine the borrower when they've missed a couple payments causes harm to the people being called. They don't have contractual relationships with the lender. They didn't expect to be called. And DFI, in its view, finds the volume of calls to all of those different people to be harassing. And it says merely missing 2 payments really isn't a basis for a, quote, friends and family calling campaign. The DFI explains that the circumstances under which references, meaning people the customer puts down when he applies for a loan, contacting references is appropriate only in limited purposes. One, to locate the debtor whose address and telephone number appear to have been changed. That's an acceptable ground to call a reference. The guidance of the DFI on this point and in the interpretive letter says that debt collectors can contact references if the customer's contact information has changed. Messages aren't reaching the customer, and not just that the customer is ducking the calls and not taking them. And contacting references is appropriate only if the lender can't get the updated address and telephone information through other means like publicly available databases. If they can't find it in that place, then it's okay to call a reference. The DFI also found that 23 calls to mother, father, stepfather, godmother, friends, and all 7 different people for just 2 missed payments also violated 1E of the debt collection statute, which is disclosing information that affects the customer's reputation. Now, none of those calls said customer has a loan, the customer's in default. However, the volume of calls, the number of the people received multiple calls, the DFI reasoned that although it wasn't expressly disclosed that the guy had a loan and that he was delinquent, it was really indirectly disclosed that he had a loan, that he must have been behind, or why were all these calls being made. Now I'm going to turn it over to Marcy to talk about some other DFI issuances of late.
Great. Thanks so much, Lisa. I'm going to skip past this slide, but just mention quickly that the department has been incredibly flexible in allowing companies to permit employees to work from home. So be sure to check out the guidance, which is posted on DFI's website, or get in touch with us if you have questions. I'm going to talk about emergency guidance issued by DFI on character and fitness requirements for licensed lenders and payday lenders. By way of background, under 13809, DFI shall issue a license to an applicant whose character and general fitness warrant the belief that the business will be operated in compliance with 13809. After a license is issued, a company is subject thereafter to periodic examination and must annually renew its license. Although the statutes do not require DFI to revisit at any particular point a company's character and fitness, DFI does have the authority to at any time revoke or suspend a license in accordance with 13809. One of the bases upon which DFI can revoke or suspend a license is if any fact or condition exists, which, if it had existed at the time of the original application for the license, would have warranted the department in refusing to issue such license. So DFI bases its emergency guidance on this fact or condition provision, and DFI has telegraphed to us that a fact or condition that would warrant denial of a company's application for a license would include a licensee increasing its customary interest rates, fees, or any costs of borrowing in response to the COVID crisis. We're hoping that Matt today can provide us with some color on the background of this guidance and if it's been relied upon or referred to yet by DFI. And with that, I'll hand it over to Matt. And Matt, thanks again so much for being here. We're really happy to have you involved with this presentation.
Absolutely. Thank you, Marcy. Thank you, everyone. I really appreciate the opportunity to be here and talk to this group today. As you can imagine, it has been kind of a wild ride for state government and for regulators of all varieties, and I know for businesses and really everyone at this time. So appreciate the chance to kind of give you a few insights on where DFI is coming from. Just in our few minutes we have remaining here, just wanted to, instead of getting into too many of the details of the guidance, I'll fill in a couple of gaps on the guidance that was talked about recently. But more than that, I just wanted to kind of do something that I wish more regulators would do. I certainly wish that, as Marcy mentioned, I was in private practice for a long time, represented a number of lenders at Foley in different circumstances and other regulated parties. And I always wished to myself and always felt something like the next slide, where it's kind of this black box a lot. Regulators certainly come out with a lot of policy and come out with a lot of guidance. And it's sometimes difficult to advise clients if you don't really know what's driving the decision-making at the agency level. You can certainly read the guidance for yourself, but it can be sometimes seem inconsistent or seem scattershot. So what I wanted to do today is just very briefly give you a kind of a decoder ring for where DFI is coming from, and kind of a guide as you're looking at DFI guidance, or if you're writing to DFI, these would be kind of the secret things to make sure you include and touch on if you want to address issues that will be something that we're considering and something that will drive our decision making. And so here's really the three things. That's it, where DFI is coming from. So once we get or address a public need for a guidance or an issue arises, and that can either come from a request from an outside party to address an issue. It often comes from associations. They may come from DFI internal discussions, or it may come simply from recognizing the economic conditions that we're going through. But once we recognize that need, there are really just three things we look at. And number one is always most important. If you're writing the agency, make sure you include something like this: is what is our statutory room to act? We are governed by statute. We can only, by guidance, we can interpret statute. By rule, we can kind of fill some gaps. But ultimately, if there's not a way to get there under the statute, if the statute ties our hands, our inquiry really stops there. The number two is the nature of the consumer interest. Is this something that affects consumers? Where is the consumer interest here? And when we talk about the consumer interest, it's not the same as the consumer interest necessarily as construed by kind of the plaintiff's bar under the Wisconsin Consumer Act. I know the plaintiff's bar, they're kind of looking for things like simple mistakes in forms, or things that can lead to a quick summary judgment that doesn't require having to go through all this trial. It can be nice and clean violations with clean and clear penalties. That's not really the way DFI thinks about the consumer interest. We try to think about that a little bit more big picture and from the consumer's perspective of really what really matters to the consumer. We're not looking for kind of the ticky-tack mistake forgotten on the form kind of violations are not the sort of thing that drives DFI decision-making, because most of the time, if they're harmless errors, that's simply not something that's going to drive DFI to act. Unless the statute, of course, ties our hands, which sometimes it does. But what we ultimately do look at very much is recognizing that the statutes were passed because laissez-faire doesn't necessarily work, that there are areas where we need to protect consumers from being taken advantage of in order for everyone to have trust in the financial industry and doing business with that. And so we're always looking at areas where consumers may be taken advantage of and taken advantage of badly. And obviously, unfortunately, in the pandemic, while our licensees we have good working relationships with, and we have a level of trust there, obviously the pandemic and the economic situation there opens up some opportunities to where people may be taken advantage of, or opportunities for opportunistic behavior that we'd like to encourage people to steer away from as soon as possible. And so that's certainly what's driven a lot of our post-pandemic guidance. And then the third thing, as mentioned, administrative feasibility. We do think of this from the business's perspective. We're trying to issue guidance that isn't going to overturn existing practices or require a lot of additional work from businesses. To the extent we can, we'd rather give guidance that gives you advice on practices to avoid rather than requiring a shift in current practices. And so to that extent, we certainly appreciate when businesses tell us what the current practices are and why things are important. So these feasibility arguments certainly do matter to us. We don't want to have people have to change a whole lot of forms and go through a lot of other hassle if they don't have to. So those are really the three things that guide us, and you'll see those play out. I can talk briefly about the guidance. I did prepare a few slides. This is a kind of a list of guidance that DFI has issued post-pandemic. A lot of different areas with some links there. I've highlighted the ones that deal with the Consumer Act. But I think I may start just by talking briefly and filling in some holes on the payday lending guidance that Marcy left off on. So with that guidance, what we did mention was, okay, we recognize there's no technical statutory cap. You know, the legislature didn't pick a number to cap fees or rates. However, we do have this general character and fitness requirement under the statute that DFI needs to evaluate, and that's a requirement for lenders in the state. That's something that people can trust, that these lenders have been assessed for character and fitness. And what we're looking at here when we're talking about raising rates is sort of recognizing the reality that, well, the CARES Act has muffled demand, at least thus far. Certainly at some point here, we're going to see a number of people who are going to need some short-term help and an increased demand for short-term lending in response to this pandemic, with the unemployment rate being what it is. And so with recognizing that this demand may well be coming, we wanted to kind of get ahead of potentially any kind of thoughts of opportunistic behavior there. What we want, we're not trying to impose a rate cap. Certainly, we're not going to question companies who keep their rates at their customary levels, or people who need to raise rates because of operational costs. If there's an explanation for it, that's fine. That's not something that's going to bother us. However, if in an exam or other situation in response to a complaint, if we do see a sudden spike in rates that isn't explained by operational costs, DFI is going to ask questions about it. And we would expect the answer, the reason for those rate increases would be something other than because we can. That's really what we're getting at with that guidance. On the debt collection guidance, kind of similar lines. And you saw, as Lisa was talking about some of the court cases and some others were talking about the court cases, you see kind of the tenor of those court cases when it comes to debt collection of late. And especially those, I know that those decisions did come out, I believe, both of them after the pandemic came. This was more of a just giving a warning to the industry, letting you know that part of what underlies the debt collection and harassment interpretation, it has changed over time. You see that in the court decisions, and you see it sometimes from judge to judge. But part of what underlies debt collection is this assumption in normal times when the unemployment rate is low, the sort of underlying assumption that this person could pay their debts. They could go out and obtain work, but they're choosing not to, and therefore a little bit of pestering, a little bit of harassment is tolerated in order to sort of incentivize people on that assumption that they could if they wanted to. With a pandemic like this and the unemployment being like this, certainly that assumption doesn't necessarily hold. A lot of industries have been shut down through no fault of anyone who's working in those industries. And that knowledge, that understanding, that's going to play in the back of judges and jurors' minds. We kind of recognize that. And so we wanted to take that opportunity to get out in front of that and let people know, hey, you know, this may be a good time to assess your current practices, to see what's necessary and what's not, to limit those debt collection practices to what's necessary and reasonable, and to for the lawyers to have conversations with their clients about, hey, the landscape may be changing there, and things that we evaluated at this risk level before the pandemic, maybe the risk level has changed here. So that's really what DFI is looking at in the debt collection guidance. And then the attorney's fees guidance is kind of an example of something where we found that the consumer interest there with those provisions, the consumer interest really wasn't affected. You know, those provisions didn't even have to be in the contract. You can get statutory fees whether you put them in the contract or not. These are sort of superfluous provisions that seem to be, I don't want to call it a gotcha violation, but is sort of a violation without any real clear demonstrable harm to the consumer. And so with that in mind, we certainly read the statute with an eye towards, okay, what's administratively feasible here? The consumer interests are fairly limited, and that's the result we ended up with. So I think I've run us right up to the full hour here, Marcy. I apologize. Probably not a lot of time for questions, but if you'll see on the last slide, I do have contact information. If you review some of this guidance, if you want to talk to someone from DFI about it, I do have the information there for our Bureau of Consumer Affairs that handles the Consumer Act, and then my contact information as well.
Matt, thanks so much.
Yeah, thank you. Really appreciate it. Sorry, Lauren, go ahead.
I know we're coming up, we've got a few seconds left, Matt, but one thing we wanted to make sure and ask you before folks start to drop off is, could you identify anything that you're seeing that might be relevant to folks on the call with respect to exams or maybe some complaints that DFI is getting in? Would you mind spending just a minute or so talking about that?
Sure. So I'll start with the easier one, which is the complaints. The good news is our consumer complaints have not been blowing up. Sometimes you worry about that with the pandemic coming. Okay, what kind of complaints are we going to see here? Consumer complaints have not gone off the charts here. Our licensees seem to be doing a great job working with people. The complaints that we do get are generally from consumers who are, looking to engage in some kind of debt modification or forbearance with lenders, and maybe they're having some trouble getting that conversation started, and they ask DFI to step in and try to facilitate that. That's certainly sort of been the tenor of a lot of our consumer complaints thus far. We've not had complaints about rate hikes by Payday or licensed lenders. We've not had occasion to apply this guidance or same holds true with debt collection complaints. We've not had a number of those out of the ordinary necessarily in light of this pandemic. So we're really kind of feeling kind of proud actually of our licensees for the way they appear to have conducted themselves. Certainly as complaints are, to the extent complaints are a reflection of that. In terms of exams, at least in the licensed financial services area, DFI essentially suspended exams for 4 months following the pandemic, really because of recognizing what licensees are going through. And to have an exam and need to be providing a bunch of information in the middle of that may be a challenge. But we have, we still do review some of the larger statistics. We do see, a lot of the signs of collection activity, replevins and repossessions holding fairly steady. We do see short-term lending actually holding fairly steady and kind of down from 2019. We suspect that that's probably muffled because of the CARES Act, and we may see an uptick coming up this fall.
Matt, how long will the emergency guidance be in effect, given that it relates to the COVID-19 pandemic?
I don't know. I mean, it kind of comes down to, we don't know exactly how long these economic conditions are going to be in effect. So, for the time being, it's until further notice. We certainly think that those are conditions that should be taken into account for as long as this economic problems and parts of the economy being shut down persist.
Terrific. Well, we are over time and we want to be conscientious of everyone's time. So we'll wrap it up. We have a couple of housekeeping items. As a reminder, this program has been approved for legal education hours. So to report your hours, click through to the CEO icon that is listed at the bottom of the screen, and a certificate of attendance, including course numbers, will be emailed to you tomorrow along with the recording of the webcast for watching and sharing. Be sure to complete our short survey, and we will use that feedback. Thanks again to the panelists, especially to Matt for joining us today, and thanks to all of you for joining us today. Have a great day. Thank you.
Thank you.